Welcome back. Our next speaker is Will Carroll. He's from the San Francisco office of Schiff Hardin. Will heads up the Schiff labor and employment practice in California, where for almost 25 years he has represented employers in trial and appellate courts and before state and federal agencies. His practice encompasses all aspects of employment law, including counseling on many of the compliance challenges facing California employers, and litigating employment matters ranging from individual arbitration claims to multi-party class actions. Please welcome Will Carroll.
I'll be talking today about a pronounced shift in the current regulatory and legislative environment, which has grown increasingly skeptical about the use of independent contractors in the modern workforce. The skepticism has taken the form of a dramatically increased effort on the part of government agencies to police perceived abuses by businesses misclassifying independent contractors. These efforts are taking place as we speak, and they've given rise to a new reality for businesses that use independent contractors as part of their business model. As a result of increased government funding, expanded interagency cooperation, the scrutiny that these arrangements are being subjected to is at unprecedented levels. At the same time, private enforcement is robust in the guise of class action lawsuits. Wage and hour class actions challenging employee classifications have increased on the federal level in each of the past 3 years. The message I have for you today is straightforward. Take a careful look at your independent contractor classifications. Confirm that you have classified properly, because the odds are growing that you're going to be asked to prove it either in court or before a government investigator. Now, over the last 2 decades, we've seen a tremendous increase in the contingent workforce. And by contingent workforce, I mean something that's non-traditional, of a 9-to-5 employee or a full-time employee. So businesses have increasingly turned to the use of contractor relationships, temporary workers, in order to address the economic demands that we've been facing in this economy over the past decade. So what are the considerations here? Principally, they have to do with a simple fact. Payroll taxes and employee benefits comprise up to 40% of an employee's total compensation. Contrast this with independent contractors. Employees are not required to make Social Security contributions. They're not required to make Medicare contributions. There's no requirement for unemployment insurance or workers' compensation coverage. No pension, no deferred compensation, no 401ks, no group health, the list goes on. You can see the range of incentives that make the use of a more temporary independent contractor relationship, there's huge economic incentive for it. The U.S. Bureau of Labor Statistics has tracked these trends, and they've estimated in 2009 that there were 10.3 million workers in the U.S., that's a little over 7% of the total workforce, that are treated by businesses as independent contractors. Now, with the pressure to reduce headcount and streamline costs has accelerated since 2009, so that the use of ICs, independent contractors, as a percentage of the workforce is only on the upswing. Don't forget that companies have a wide range of obligations once that employment relationship exists. So the difference between an independent contractor and an employee is stark. If you have an employee, you have wage and hour obligations. You've got leave obligations, family leave obligations. You've got minimum wage, mandatory breaks, unemployment insurance. If there's a legitimate independent contractor relationship there instead of an employment relationship, none of those obligations exist. So you can see there's a range of incentives on the part of businesses to use independent contractors. These incentives occur against a legal backdrop that is cast in shades of gray. And I say that because the standards for determining an appropriate classification, that is, at what point is an individual an employee or an independent contractor, the standards are vague, they're fact-specific, and they differ from jurisdiction to jurisdiction, oftentimes within the same jurisdiction, depending on what statute you're talking about, The standards can be different, sometimes subtly different, sometimes the differences are stark. But it is a very complex and fact-specific driven inquiry. There's no simple test. With the strong incentives to use independent contractors, and with this vague, gray legal backdrop for determining the proper classification, you could see that the potential for misclassification is significant. A labor department study, Department of Labor, found in 2000 that 30% of the employers it audited had engaged in IC misclassification. The GAO updated that recently and estimated that the number of misclassified workers had increased by a factor of 50% since the DOL 2009 study. So there's this perception afoot that IC misclassification is rampant. In the face of the fiscal challenges facing the government at all levels, it's not hard to see the appeal from the government standpoint in pursuing IC misclassification. The DOL projected that if only 1% of employees nationwide were misclassified, it would result in loss of unemployment insurance contributions exceeding $200 million. That's just if 1% were misclassified. State governments are feeling the same pinch. So on this issue, deficit hawks, on the one hand, can join hands with workers' rights advocates on the other, who want to see employment laws expanded to cover the greatest number of individuals possible. And the result is you have a sort of strange bedfellows who are interested in advancing this crackdown on independent contractor classification. Unions also play a role. Independent contractors can't vote in union elections, they can't pay union dues, so unions have emerged as a force pushing enforcement by regulators, that targeting certain industries, targeting certain companies, and they're also, of course, a strong force on the lobbying front. So this slide has got the DOL's perspective. This is from a commission on the future of worker management relations. I'm only putting it up there because it reflects a couple of themes here. First of all, in the first paragraph, this has got a very narrow characterization of the independent contractor relationship. Entrepreneurs who bear the risk of loss, serve multiple clients, hold themselves out to the public as independent businesses. Well, that is true. Independent contractors fit that definition, but that is a very, very narrow characterization of the independent contractor relationship, and it sort of betrays the direction from which DOL approaches this. The second paragraph reflects the underlying motivation, and it's clear enough. Misclassification costs federal and state treasuries large sums in uncollected Social Security, unemployment, personal income, and other taxes. So with all these various incentives, what is going on now? The DOL has announced what it has characterized as a misclassification initiative. And there's various components to this initiative, and it's against the backdrop of various other initiatives that are all focusing on this issue. So one of the more concrete manifestations of this misclassification initiative are memoranda of understanding that the Department of Labor is entering into. The most significant one occurred last fall, where the DOL entered into an MOU with the Internal Revenue Service. And pursuant to these memorandum of understanding, they involve the agreement to exchange information, to hook up data sharing, and to coordinate enforcement activities. So you can see it's a very powerful device. DOL has also had a great deal of success in entering into these MOUs with individual states. So you've got a federal-state nexus here as well. And the activity is significant. So you've got 16 separate states and counting between the individual states with the DOL, including most recently California. What information is being shared? So the sharing consists of broad categories of information. unemployment compensation information generated from unemployment claims, where independent contractors decide, hey, I'm off of work, maybe I'm not really an independent contractor, maybe I'm an employee. That generates claims and disputes, and employers take positions in these disputes. They will, that unwittingly, they may be taking positions that are going to end up being fed into a federal database and will commit them to a position in government audits that occur on the federal level. So it's very important to be viewing these, what in the past has often been viewed as a sort of mundane, routine claim for unemployment benefits, and recognize that this information, when the employer goes on record in one of these proceedings, that information is becoming available to, on the federal level, IRS, DOL, and potentially to other states as well. So you can have multi-jurisdictional coordination of things that traditionally have only occurred on the local and state level. So it's a good idea in advising your clients on this specific issue of independent contractor classification to make sure that you have some kind of coordinated effort in responding to these claims as they come in on the local level, making sure that ideally that they're reviewed by counsel or at least by a human resources executive who's responsible for ensuring and enforcing a consistent approach from jurisdiction to jurisdiction. Okay, so there's the old saw of following the money. The Obama administration in the last 2 fiscal years has included substantial funding for independent contractor misclassification. The specified goal of this funding is to detect and deter companies from misclassifying employees as independent contractors. The current fiscal budget, the 2013 budget allocates no less than $14 million to these efforts at targeting IC misclassification. 70% of that is dedicated to the states to recover unemployment and income taxes. This money is being used for, in a word, for enforcement, comprehensive and creative enforcement. So the budget identifies a number of industries that the DOL is likely to crack down on. I can tick them off: construction, janitorial, home health care, child care, transportation, warehousing, meat and poultry, hospitality, communications. They're all in the crosshairs. DOL, is, in conjunction with state agencies, is using traditional investigation methods as well as new, more innovative methods, the new media. They're also adopting a PR approach to the issue. The DOL has decided that part of their agenda is to mobilize public sentiment against independent contractor classification. In part, I think, because the activity that's occurring on the legislative front and some of the bills that we'll be talking about in a moment. In any event, the DOL has made a great deal of effort to publicize its enforcement activities. In the last 60 days, they've issued press releases, one for a $500,000 settlement with 2 Chicago cleaning companies who had misclassified cleaners, another $250,000 settlement with a Texas power company. The website contains scores of press releases relating to settlements and judgments against employers who have misclassified. One interesting development in the past year is that DOL has adopted a naming and shaming strategy. So they have released an app for iPhones and for iPads, and it's referred to as Eat, Shop, Sleep. And at first glance, it appears for all the world as a typical app which allows you to search for hotels, restaurants, stores, get user reviews, locations, maps. But there's one feature to this that most don't have, which is there's a highlight button, a DOL highlight button that will reveal the number of labor law violations this particular business has been found to have engaged in, as well as the back wages that have been awarded employees. So users are encouraged to screen out businesses that, from their search activities, that have been found to have engaged in these misclassification activities. Legislatures have been busy too. So I mentioned a moment ago that there's some activity on the legislative front. And one of the more significant initiatives that has been pursued in Congress is an effort to undo Section 530 of the Revenue Act of 1978. Now, what is Section 530? It's a very significant tool that employers have been able to rely upon in seeking and obtaining protection from back taxes for having misclassified employees. So by invoking Section 530, the taxpayer can avoid any kind of effort by the IRS to reclassify workers from independent contractor to employee. It's a safe harbor. The requirements include that you have a reasonable basis for treating the workers as ICs, that you've consistently treated the workers as ICs, and that you haven't treated any substantially similar workers as employees. So this safe harbor is currently under attack by a bill known as the Fair Playing Field Act of 2012. And if successful, this legislation would eliminate the Section 530 safe harbor and subject many employers who have relied for the last 30 years on the safe harbor for classifying certain groups of employees, of workers as independent contractors, would no longer be able to do so. They wouldn't be immediately subject to assessments for having misclassified those employees, but going forward, they would be forced to treat the employees, the workers as employees instead of ICs. This is the second time in 18 months which Congress has introduced a bill trying to eliminate the Section 530 safe harbor. And the principal sponsor refers to Section 530 as a tax loophole that needs to be fixed. And DOL has released an estimate claiming that the elimination of the loophole and related measures would result in savings of more than $7 billion over 10 years. The bill is currently in committee. It's not expected to make it to the floor for a vote, but depending upon what happens this fall, it's a bill that will likely make a reappearance in a second Obama administration. Another program, a new initiative by the Internal Revenue Service is the Voluntary Classification Settlement Program. And this is something that you all should be aware of in the event that your client is considering participating in this program. It's important for you to be able to advise the client about the potential risks. Because at first blush, it's an appealing program in that it allows businesses to reclassify individuals as ICs where so as to avoid any back taxes. It's in effect an amnesty program. You get 90% amnesty for back taxes and you reclassify. The difficulty with the program, however, the potential difficulty is that the amnesty only applies to federal tax liability. So that if you do reclassify, you're still subject to possible enforcement activities, back taxes at the state level and by other federal agencies other than the IRS. So I'm getting some signals from Ellis. I'd like to briefly address some remedial measures. So I wanted to just give a couple of brief points about advising clients on how to restructure and increase the likelihood that your independent contractor classification is going to withstand scrutiny. So the most important feature of this is to increase the amount of autonomy that individuals have. And this can be done essentially by loosening the reins. And that means that you try to structure the relationship. We're all familiar with alternative billing arrangements for attorneys. Well, the same sort of creativity can be brought to bear with contractor relationships. And so by creating incentives in the form of fixed fee relationships, you put the onus on the contractor to determine their hours, to determine whether they make money or lose money on the relationship. You avoid micromanagement, and in so doing, you avoid a finding that the degree of control that you're exercising is going to be held to give rise to an employment relationship. Ladies and gentlemen, I'm afraid that's all the time I have. I have some other issues I intended to cover. I apologize for that. I'd be happy to chat with any of you. If you feel free to approach me or shoot me an email, and I'll be glad to respond. Thank you very much.